But if Jerry at the scene sniffs and changes his posture, and I'm going to get into that in a moment, and there's an alert, and then the car is ultimately searched, and there are no concealed humans and no drugs of any kind, or said another way, Jerry was wrong, do you keep a statistic there?
You can't know that the canine was wrong in that instance, because the canine is trained to find the odors of. If the individual had smoking marijuana, or if there was odor within the vehicle prior to arriving to the point, the dog's going to alert to that also, because the dog's trained to find concealed people and the odors of narcotics. It's just
Okay, so let me understand your position then, sir. Your position is that when the dog is walked around the vehicle and the dog does something to indicate to the officer that there's an alert, and then the officer puts up the two fingers to give the signal, and then there's a search, and there's no concealed humans in the vehicle, and there are no drugs in the vehicle, the official position of the Border Patrol is the dog wasn't wrong. The dog was indeed correct that there were odors of concealed people in the vehicle or odors of illegal drugs in the vehicle. Is that your position?
That's my position, because you can't know whether those things existed.
Okay.
As if you were to...
I understand your position. Thank you. Let me ask you a different question now. When the dog Jerry alerts, and then there's a search conducted, and there are no concealed persons found, and there are no drugs found, is there a record made somewhere that there were no concealed people found, there were no drugs found, and yet there was an alert?
Objection, Your Honor. This question's been asked at least 3 times concerning the accuracy log. It's been asked and answered.
Actually, Judge, I haven't asked that question because he said there's a scent, and now I'm distinguishing the issue of a scent versus actually finding something that's useful.
Objection is overruled.
Please again, sir, I'm sorry.
You keep a record of the times that Jerry alerts and nothing is actually found?
No, sir.
No record at all?
No, sir.
Therefore, you have absolutely no idea, do you, on what the rate of times that Jerry alerts and nothing is found, do you?
We don't have any idea of that.
No idea. Thank you.
Defense counsel went into depth about false alerts. Is there any such thing as a false alert?
There's no such thing as a false alert. There's no such thing as a false alert. There's no such thing as a false alert. There's no such thing as a false alert.
I would have been happy to make the motion had the state's own witness not told me that these documents simply didn't exist. Had the state's witness said, yes, there are documents out there, I personally don't have them, fine. But just to be safe, I requested specific information about the specific dog in question months ago from Mr. Katz. I don't dispute, I have no reason to think that Mr. Katz didn't follow up on that, but that's not relevant. Mr. Katz himself, he's not the state. Mr. Katz is responsible, and I don't need to tell the court about Brady versus Maryland and Kiles versus Whitley. Mr. Katz has a responsibility, even without me requesting this information, to get it for me. Here, I specifically requested that information. I was specifically told by the state's witness it didn't exist. Today we learn it exists. Here I have a letter that says we're not going to give you everything, but we'll give you some things. What things? Oh, exactly what I requested months ago. So sure, we can delay the trial again, but I know that this court is well aware of my Rule 8 motion to dismiss, where after the Rule 8 time limits. Yes, I understand the court's ruling. The court made some rulings that Mr. Katz's ongoing changes of judges and all kinds of things that forced myself and my client to take time out of our day and drive down from Phoenix to push this matter back so far that we are actually on the verge of starting jury trial tomorrow. And so now, at almost 3 o'clock in the afternoon, while the state still has 2 more witnesses to go, and I may have an option of calling a witness, or 2 if I decide, the night before trial, where even if the state could get these documents, now I'm to review them, digest them, conduct a new interview based on new information that I should have had months ago, and then recall the witness to ask further questions that go to my motion to suppress, which should have been included in my motion to suppress, which I filed months and months and months ago. Judge, this is outrageous, and I'm not faulting Mr. Katz personally. Mr. Katz may have done everything within his power, but it's not good enough. If the state is too big and too incompetent to follow their duties and follow their obligations, they shouldn't run a checkpoint like this where they stop thousands and thousands of citizens. If If I was in charge of that checkpoint and I was stopping thousands and thousands of citizens based on the opinion of a dog, which is exactly what we have here, I might be prepared to produce, especially when asked, the records of that dog. It's outrageous, Judge, and there is no remedy, none, short of dismissal with prejudice, that would be appropriate in this circumstance.
Mr. Victor appears outraged, and I can understand why.
Judge, unless the state is going to now put up witnesses that are going to contradict things that this agent just said, I don't see any point in moving forward with this hearing. If that's the state's witness and that's the state's evidence, then what we have now is the clearest possible scenario of a checkpoint that is not just an immigration checkpoint. This is a general crime control checkpoint. This agent has now testified that among the various things that this checkpoint exists to accomplish is to detect drugs. That's the end, Judge. Drug checkpoints are unconstitutional. They're unconstitutional, and there is no argument that they're not unconstitutional. The state's witness testified that this checkpoint has multiple purposes, one of which is to detect drugs. There are several other purposes that are also unconstitutional. The Supreme Court has ruled that immigration checkpoints can be, under certain circumstances, which was the primary avenue of attack, that they didn't follow those circumstances, which, by the way, is still our argument. The Supreme Court has said that DUI checkpoints, under certain circumstances, are constitutional. But they have also said, clearly, that general crime control checkpoints, like checkpoints for drugs, like this checkpoint, as evidenced by the state's witness, are flat unconstitutional.
Your Honor.
As if we needed anything else, Judge.
Your Honor.
He's already testified, in addition to that, that there aren't even any guidelines, even if this was solely for immigration. There are no guidelines. He has no idea what even would be done if somebody shows up and says, no, I'm not a citizen, individual officer's discretion. If somebody shows up and says, I refuse to answer, no idea, individual officer's discretion. No guidelines, no policies that deal with that. The policy he's getting, I'll take him at his word, Judge. He says it has nothing to do with operations. It may not be relevant. If he's right about that, and that's the state's evidence, that doesn't get us where we need to go.
Are you asking the court, and I will give you an opportunity to address the court, Mr. Katz, are you asking the court to make a ruling based on the testimony that I heard without listening to the other witnesses, because it may be the same testimony, and we just wait for the document that you require that may not be relevant at all, may not have the information that you're looking for, and then the court makes its ruling regarding this motion?
It's certainly conceivable, Judge, that the state may say, that witness that I just presented, he said things I didn't expect, and that I think he said things that were wrong, and I'm going to present other witnesses that say different things than this witness. Okay, that changes my position. But if the state's not willing to say that, if the state is wanting to say what he said, what I just presented, is the truth, that's our position, there's no sense of taking any further evidence, because now
You didn't answer my question.
Well, I think it's based on what the state's position is. But in essence, Judge, if the state says their witness, the information their witness just presented, I think the court has enough evidence right now to rule, and should, that this entire checkpoint is unconstitutional, and that should be the ruling. And I think anything else we do today is just a waste of time, unless the state's going to try to change the testimony that's already come out.
Mr. Anderson refused to go to secondary.
Yes, sir.
Why didn't you arrest him?
Objection, Your Honor, relevance.
Your Honor, they opened the door when he asked what his role after this point was on the tape. He asked him what his role was, and now I'm delving into what his role was.
Objection is overruled.
Why didn't you arrest him?
At the time, I didn't have a reason to arrest him, sir.
He hadn't committed a crime?
No, sir.
No violation of federal law?
No, sir.
Are you, or were you at the time certified to enforce any state laws?
No, sir.
Are you now?
Yes, sir.
What are you cross-certified to do regarding state laws now?
Issue citations for narcotic violations, sir.
Anything else?
That is it, sir.
Only narcotic violations.
Yes, sir.
To the best of your knowledge, was that the status of canine officers on April 14th?
Can you state the question, sir?
To the best of your knowledge, on April 14th, was it the status of canine officers, specifically Agent Spoonamore, that he could enforce state laws, but only to the extent that he could write citations for narcotics violations?
No, sir.
Could he enforce more state laws?
Not to my knowledge, sir.
Okay, so the answer to my question would be yes, that's, to the best of your knowledge, that's all he was allowed to do. I want to make sure I'm not trying to confuse you. If I ask you a question and you don't understand my question, please ask me to repeat it. Sometimes I lose track from the beginning to the end. To the best of your knowledge, on April 14th, was Agent Spoonamore's authority as it respects state laws only to issue citations for narcotics violations?
No, sir.
Then what was your understanding?
The K-9 team is also there to look for concealed people, sir.
I'm talking just as respects state laws, not federal laws. I assume you all are empowered to enforce federal laws, okay? Just state laws. The only thing Agent Spoonamore could do is write citations for narcotics violations.
To my knowledge, yes, sir.
That's the way it is now?
Yes, sir.
To the best of your knowledge, it wasn't any different back then?
Yes, sir.
Mr. Katz.
Your Honor, as a procedural formality, I've seen this done many times, and I say this respectfully to counsel at the defense table. For the purposes of this hearing, counsel needs to select one representative who will be speaking for the defendant, Your Honor. That is typical of these hearings.
Judge, just to respond to the other issue in terms of who's going to speak, I've had the privilege of trying several cases with other attorneys, and I've never once been restricted to just sort of one lawyer for the entire proceeding. The restrictions that to my recollection, that I have always had are per witness. In other words, one attorney will handle one witness, or will be assigned a particular witness, and then if they choose to have a different attorney to handle a different witness, that's fine. So we don't intend to have both of us asking questions of the same witnesses. We intend to have one attorney, which could be me, could be Mr. Campbell, for each witness. That's how we would intend to proceed. I don't think anything's inappropriate about that.
And Your Honor,
I'm not concerned about that. I think Mr. Katz addressed it in a way that I wasn't sure if he wanted me to request that you assign one attorney to be the one speaking all the time, or I don't have any problem at all.
and Your Honor, does that also apply to one attorney making opening and closing remarks concerning the constitutionality of the search, or will Mr. Victor be able to give his opinion on the constitutionality at the close of these proceedings as well as co-counsel?
I think that they're going to make a decision between the two of them who's going to address the court and when. I'm not sure what your concern is.
My concern is that the waste of time, which is being proffered by defense counsel and originally playing this video, if we're going to have numerous comment on the same legal issue in closing from both defense attorneys, Your Honor, I mean, the state has potentially 13 prosecutors who are well aware of Martinez Fuerte, who can all give their opinion, and an educated opinion on that, since Martinez Fuerte was decided, I believe, in the late 70s. It's a case that's well known. I'm just trying to focus the inquiry, and that one attorney...
Mr. Katz, trust me, I'm interested in making sure that this case moves along as quick as possible in the interest of justice. Once again, I mentioned before, the interest of time, in my opinion, is borderline violated at this point. So we got this whole day for this hearing. I'm giving people an opportunity to have their their time to address the issues, and I have full confidence in the two attorneys sitting in the defense counsel table, like I have full confidence in you that you're not going to waste this court's time any longer.